We're here because we recently filed a lawsuit against the state of California for several causes of action. One is a failure to provide adequate funding under California Health and Safety Code Section 11361.9. That is basically the marijuana expungement law. The second cause of action is a violation of Article 1, Section 7 of the state constitution, which basically is equal protection. What we're saying is that the funding system of the state of California for the courts discriminates against people of color. Also, we allege violation of California Civil Code Section 52, which is also known as the Unruh Civil Rights Act. Basically saying that the defendants or the state of California's funding formula for the courts basically ensures that people of color that need Riverside and San Bernardino County courts actually are going to have less resources per case than other state courts. And even though we say that this is exemplified by the issue with this marijuana expungement law, it is a larger state issue that doesn't just come or go with the marijuana expungement law. We also seek declaratory relief. So, as the lawsuit states, the court provides a process through which individuals can vindicate their legal rights. The federal and state constitutions have long recognized the importance of equal access to the courts for preservation of the rule of law. Fundamental to that access is adequate funding. Whereas the judicial system exists to provide even-handed, unbiased, and competent administration of justice, inadequate and disproportionate funding can sabotage the court's ability to function and process cases evenly. So, the key arguments that we make are that the funding that currently comes from California to Riverside and San Bernardino County courts is inadequate to deal with this state mandate from Assembly Bill 1793, which is basically the marijuana expungement law. We also say that state funding is inadequate for the Riverside and San Bernardino courts in the first instance, which is the underlying and long unsolved problem. Finally, the foregoing is discriminatory because the racial makeup of these counties, both being majority-minority counties, and the disproportionately punitive nature and effect of the criminalization of marijuana offenses on people of color means that people that need the most help actually get the least amount. So, while the expungements of marijuana convictions records of many counties is already done, this flows, as we'll talk briefly, from AB 1793, which was passed in 2018. For many counties, it's been done for months. Richer counties, counties that have more resources, counties that have more of everything in terms of their court systems. By January of this year, none of them were done for Riverside or San Bernardino County, not even one. Riverside County had about 21,000 to do. The 2,600 infractions and misdemeanors had been reviewed, but none of the 17,000 felonies. 17,000. San Bernardino County had about 5,400. The number may be more. It seems a bit low, but it was several thousand, and none of them had been reviewed and exchanged. By contrast, Santa Clara County finished all 11,500 cases it had to review and expunge by April 2020. Los Angeles County finished all 66,000 that it had by late 2021. So, going back to go forward, in 2016, most people know that California voters legalized cannabis for recreational use. This law came with a promise to create a legal pathway through the courts for clearing over 200,000 post-marijuana related convictions, past marijuana-related convictions, or reducing them to a lesser charge. To speed up that process, the how was AB 1793, which was passed in 2018. Through this legislation, the state shouldered the financial responsibility to automate the process of identifying eligible cases and ultimately expunging them unless there was some kind of objection from the DAs in the different counties. because everyone knew that the state was the one with the resources to actually help to make this happen. Okay? The expectation was that the state's funding would allow all state courts to process cases in a timely manner regardless of the county. Now, this is a huge issue, as we know, because many people are kept from getting jobs, housing, or other services because of the felonies on their records. It would make sense that something that is no longer a crime should not be impediment to going forward. Going back to go forward a bit, for a long time, state courts depended in large part on the county's ability to raise revenue, which meant that funding relied on what the localities would do, particularly the county boards of supervisors, et cetera, on their discretion. And so as a result, some counties had well-funded courts and other counties did not. As early as 1969, judges and legislators alike began pushing for a constitutional amendment that would require that the state and not the county governments would fund the trial courts, because what they were providing was entirely too important for it to come or go based on what county they were in. So several initiatives followed over the years, including the Trial Court Trust Fund, the Trial Court Improvement Fund, and the Judicial Administration Efficiency and Modernization Fund. There was a 2002 measure that shifted ownership and maintenance of court facilities from counties to the state. The problem is, while the states recognized that the courts would not be equitable without state funding, the state never really finished the job. So let's talk a little bit about how that affects Riverside and San Bernardino County and why we really needed to work and why we filed this lawsuit. Inland Empire is a majority-minority area. Currently, San Bernardino County is California's most populous county, most populous majority Hispanic county at 54.7%, and the second largest majority Hispanic county in America. It's also 9.4% Black, 8% Asian. Likewise, Riverside County is 50% Hispanic, 7.3% Black, 7.3% Asian, 34.1% white. Poverty is higher in the Inland Empire than in California and in the United States as a whole. These and similarly underserved communities were the ones, by the way, that were most adversely and acutely suffered. They underwent the most suffering related to the effects of the war on drugs. Indeed, despite marijuana usage being roughly the same among white, Black, and Hispanic people, Black and Hispanic Californians had much higher arrest rates than their white counterparts. These numbers increased dramatically between 1990 and 2009, coinciding with the Crime Bill 1994 that was passed federally. According to the State Department of Justice, from 2006 to 2015, Black Californians were 5 times more likely to be arrested for cannabis felonies than white Californians, despite using and selling cannabis at similar rates. Similarly, Hispanic Californians were 35% more likely to be arrested for cannabis crimes than white people were. Moreover, a 2020 report shows that though the national usage marijuana rates are roughly equal for African American and white Americans, and the lifetime usage rate for white Americans is actually higher by roughly 8%. The national arrest rates for African Americans are higher. In California, the average marijuana arrest rate in 2020 for everyone was 9.14 arrests per 100,000 residents. But for Black Californians, this number is 18.12 per 100,000. Compared to white Californians, and it's higher for Hispanic Californians as well. And by the way, all of the facts that I'm giving you are outlined in the complaint. Overall, empirical evidence demonstrates that penalties for cannabis-related offenses have disproportionately affected people of color. So, fast forward to AB 1793. The state took responsibility for funding the rollout because it knew that significant new burdens the significant new burdens that carrying out the law would impose on the courts, and acknowledge that the capabilities of each court's case management systems, court staffing levels, and potential objection from the prosecution even, because that was a possibility, should influence the workload estimates and funding formulas. So the Judicial Council had projected a one-time state general fund cost to the courts between $6.9 million and $28.5 million. But the courts received what is an inadequate number, $16 million, from the state budget to pay for the cost of processing the records across all 58 counties in California. Moreover, and most importantly, the state failed to provide the appropriate apportionment for courts that faced greater challenges in clearing the records. Instead, the Trial Court Budget Advisory Committee unanimously voted to adopt a proportional allocation methodology based on the percentage of potentially eligible cases by county. And the state rejected the alternative funding mechanisms that would consider the number of cases a court actually handles, their complexity, and their available staff and technological capabilities. San Bernardino and Riverside County are home to a significant population of low-income minority communities, many of whom have time and time again disproportionately suffered the blows of the war on drugs, and they don't get to reap the benefits of the record clearance laws despite needing the resources the most because their courts are less equipped. So, what do we have in the way of resources? Pre-COVID, things were difficult, okay? Pre-state mandate from AB 1793, things were difficult. San Bernardino and Riverside County courts were already overburdened and understaffed compared to other counties. Nearby counties had more judicial positions or position equivalents than Riverside or San Bernardino, even while having less filings. So, for instance, while Los Angeles has 578 judicial position equivalents county, San Diego 152, Orange County 154. San Bernardino has only 92 and Riverside barely 90. So you would say that can be explained by more population, right? Well, true if you only include population and number of judicial positions. But you see the problem when you examine the number of court filings per judicial position across the counties and the number of staff. So, as to court filings per judicial position, San Diego County, each judicial position handles 2,574 court filings, 2,574. Riverside County, that number jumps to 3,228 per judicial position, increased burden of some 700. For comparison, back in 1993, when it was recognized that this really needed to go from localities to the state, even then, the funding, all of that time ago, statewide, the total filings per judicial position in California was only about 1,100. As it pertains to staff, San Bernardino, Riverside County has less staff as well. So, for instance, and has an overwhelming number, by the way, of more complex forms of litigation. In 2019 and 20, Riverside County handled 24,206 court trials with 1,086 full-time employees, what we call FTEs. So in other words, Riverside County had 22.29 court trials per full-time employee. By comparison, Los Angeles County, 6.94 court trials versus 22 per full-time employee. San Diego County, 3.97 court trials per full-time employee. The data also suggests that Riverside and San Bernardino counties have higher numbers of criminal filings per full-time employee. Riverside has 181 criminal filings per full-time employee. San Bernardino, 194. Orange County, 8.11. Los Angeles, 63.11 criminal filings versus 181 for Riverside County versus 194 for San Bernardino County. Thus, employees in Riverside County handle on average over 23 times as many criminal filings as do their counterparts in neighboring Orange County. So, didn't want to overwhelm you with numbers there, but I think that this resource discussion is a good time to bring in Sarah Rodriguez, who is our named plaintiff, whose reality, and by the way, this is a class action, and she is a class representative, and her reality and experience with the court system helps to demonstrate the resource problem that the state has to fix through our courts that we hope starts with this case. Sarah, you can take your time now.
Okay. My name is Sarah Rodriguez. I'm a 40-year-old Latina woman that comes from modest means. I am currently employed as a post-conviction social worker for the Los Angeles County Bar Association. Many years ago, I was convicted of possession of marijuana for sales, a felony in San Bernardino County, and was subsequently sentenced to 2 years in state prison. In total, I spent close to 8 years, either on probation, on parole, or incarcerated. I spent most of my 20s entangled within our criminal legal system, and most of my 30s working hard to put my life back together. In an effort to negate the negative impact that a background check would have on my future job prospects, I decided to pursue higher education. I became the first in my family to attend college, and in 2017, I graduated from Cal Poly Pomona with a bachelor's degree in psychology and a minor in criminal justice. I went on to attend graduate school at UCLA, and in 2021, I earned a master's degree in social welfare with an emphasis in social and economic justice. For close to 2 decades now, I have lived with a felony on my record. In fact, my career path was partly dictated by what I thought may be limitations in what I can do, considering I had a conviction history to account for. While in community college, I asked an academic counselor what kind of majors or careers were felony friendly, only for her to reply, "What is a felony?" I left her office feeling lost and unsure of my path forward, but committed to pursuing higher education and hoping that I would find the answers I was searching for once I transferred to a university. Fortunately, during my senior year at Cal Poly Pomona, I became connected to a professor that created a nonprofit that provided volunteer opportunities to work with those both formerly and currently incarcerated. It was only through becoming active in the formerly incarcerated community that I was able to meet 2 other people with felony convictions that were also social workers, and this gave me hope that I too can be successful in this career path. From their mentorship, I was able to realize that what I viewed as a liability, my conviction history, could in fact be an asset, depending on the population I chose to serve. Since 2017, I have been focusing my outreach efforts on assisting and mentoring other formerly incarcerated folks who are interested in pursuing higher education. It has been an opportunity to give meaning to my experience while also sharing my knowledge of the transformative power of higher education, so that they too can have hope and succeed in their educational endeavors. While many people work in careers that are unrelated to the criminal conviction they have, the work I do reminds me of my own incarceration experience, the obstacles I've had to overcome, and the hope, redemption, and power of second chances. Due to my training, I am very familiar with the process that needs to be normally undertaken in order to expunge a conviction. Normally, a person that has a conviction that can qualify for reduction or expungement must bring a motion to the court after the requirements have been fulfilled by that person. It puts the onus on the person to bring the case before the court. This presents a couple of obstacles for people of modest means, including people of color. First, knowing how to navigate the court system, which is difficult enough, and second, having a court system that does not have the resources to be responsive. With this in mind, when I heard about the passage of AB 1793 and what it could do for me and people like me, I was very excited. AB 1793 provided a legal pathway through the courts for clearing many past marijuana-related convictions or reducing them to a lesser charge. It was a logical next step after California voters legalized cannabis for recreational use in 2016. Surely, almost everyone can agree that something that is not even illegal anymore should not be an impediment for a person to have a job, to have a place to live, or have to succumb to the over 44,000 legal barriers that affect those with conviction histories. Unfortunately, on that day nearly 20 years ago, in addition to the obvious poor choice I made, I had the misfortune of being arrested and convicted in San Bernardino County. As of this past January, neither San Bernardino nor Riverside County had cleared any of the convictions that were eligible for expungement under AB 1793. This is despite the fact that the law's passage in 2018 required that cases would be sent by the district attorney's office to the courts by July 1st, 2020. As I sit here today, I do not have confirmation that my conviction has been removed from my record, even though it qualifies for removal. Fortunately, I have a career in education and can be a voice of reason and calm for others like me. Unfortunately, I and many others in San Bernardino and Riverside County still stand convicted of something that is no longer a crime. While I understand there is further legislation to help speed up the conviction removal process, the damage continues to be done to me and others like me with qualifying marijuana convictions in San Bernardino and Riverside County. My personal story and the AB 1793 implementation problem shines light on the larger issue of court funding that this lawsuit is about. Specifically, that San Bernardino and Riverside County seem to get woefully limited resources to carry out its responsibilities, including mandates from the state. While in graduate school, I was extremely busy with classes, homework, completing my program's 16 to 20 hour a week internship requirement, working part-time, and being a mother to my teenage daughter. So I was relieved to hear about the passage of AB 1793 and recall thinking to myself, by the time I'm done with graduate school and ready to enter the professional world, my felony would have been automatically removed. What I did not realize at the time is that this law would not be enacted equitably across counties. My personal experience with Los Angeles County and San Bernardino County helped to prove this point. This past October, I was preparing to apply for registration as an associate clinical social worker with the Board of Behavioral Sciences and had to account for any past criminal convictions on their application. So I went to the Los Angeles courthouse to inquire if I have received Prop 64 relief and would not have to account for my felony on my ACSW application. It was only then that I learned that although I was a resident of Los Angeles County, since my county of conviction was San Bernardino County, I had to go back to the court of my conviction to inquire about Prop 64 relief. Had my county of conviction been Los Angeles County, I would have been included in one of the 66,000 Prop 64 cases that automatically received post-conviction relief. So for me, that meant an hour-long drive to Victorville Court to inquire about the process and to acquire the necessary paperwork so that I can submit my ACSW registration. I was told by the Victorville court clerk that since my case was so old, my records were in storage, and it would take a few weeks to locate. As a social worker, I am trained to navigate systems, and after further speaking to the clerk and agreeing to visit 2 different offices in Victorville and another in San Bernardino, and paying just short of $100, that day I was able to acquire the necessary documents to complete my application with the Board of Behavioral Sciences. Regarding Prop 64 post-conviction relief, while at Victorville Court, I spoke to the clerk in the public defender's office and was told to email them to initiate the process. So I emailed the public defender's office inquiring about Prop 64 relief and received an email stating a list of things to do in order to initiate the process, which included filling out an authorization waiver, writing a personal explanation to the court explaining why I am seeking relief, and obtaining live scan fingerprinting, which from my experience costs approximately $50 to $60. Additionally, I had to wait 6 to 8 months for the process to be complete after submitting these documents. I am familiar with both the process of obtaining a live scan and having to explain my conviction, as I've had to do so both times to be cleared for my internship placement as part of my graduate program at UCLA. Then I also thought about everyone else who is eligible for Prop 64 relief, but may not be familiar with the process. So it may feel overwhelming and burdensome for them, both time-wise and financially. I also felt, why should I have to wait an additional 6 to 8 months for relief and pay money to do something that by law is something that should be initiated by the courts and automatic? I agreed to be a class representative for this case because something has to be done to fund San Bernardino and Riverside County courts at a level that allows them to be responsive to its citizens. As a formerly incarcerated social worker, I feel both a duty and privilege to be able to advocate for those with conviction histories who are entitled under the law for post-conviction relief. Even if AB 1793 issue is resolved, there is a fundamental lack of funding that keeps people that need services from San Bernardino and Riverside County courts, like me, from getting the help they need on a timely basis. These courts are always working from behind, with AB 1793 as an example. And the pandemic just made a bad situation worse. Whether it is getting a case concluded or getting a conviction expunged, people like me should not have to be at a disadvantage because the county where we need service is drastically underfunded and under-resourced. My hope is that this case can draw attention to a problem that is long overdue to be fixed, and it must be, because justice delayed is often justice denied. Thank you.
Thank you very much, Sarah. Those words are extremely powerful. And what I want to point out is that Sarah is someone whose job it is to actually navigate this system. And she's talking about the problems that she's having navigated. So for everyone like her who has done an incredible turnaround story and has made a decision to help others, there are 4 or 5 people and made it part of her life, her day-to-day life. There are several other people who have a job that's not connected to their conviction, who don't know how to navigate the system, and who are frustrated and often discouraged from starting to navigate the system, particularly if you don't know where to start and you heard that AB 1793 was supposed to get this done without you having to do anything. So in addition to commending Sarah, I want to commend our courts in general, judges, clerks, staff, and particularly for Riverside and San Bernardino County. They have to do more with less. They serve the underserved with commitment and with vigor and against enormous odds, sometimes impossible odds. It's their plight and that of the people that they serve that makes this case necessary. So to be clear and to remind, we're talking about AB 1793 as endemic of a larger problem. And that larger problem does not go away if Sarah, as a woman of color who needs services in San Bernardino County, and convictions and others' convictions are finally expunged 2 years after they should have been. Okay, that's not going to solve the problem. AB 1793 serves as both a necessary step in the right direction, which we commend, but also a clear reminder of the problem that we have with the funding of San Bernardino and Riverside County courts and how it affects people of color. To be reminded, poverty is higher in the Inland Empire than in California and in the United States as a whole. Social mobility has long been consistently low. The Inland Empire is one of the least educated areas of the state, with the lowest average in annual wages in the country. A 2006 study of salaries in 51 metropolitan areas in the nation ranked the Inland Empire second to last, with an annual wage of $36,924. Unemployment rates there have consistently been over the national average. In the Inland Empire, about 54% of those living in poverty are Latinx. You heard Sarah just talk about coming up with money to get a live scan and all the dots that you have to connect. They shouldn't have to do that as it pertains to something that is supposed to be removed automatically. These are poor counties, less educated, with larger percentages of people of color, and with more exposure to the convictions that AB 1793 was supposed to get rid of. So, and in short, as it pertains to funding for Riverside and San Bernardino County courts, we need it more, but we have it less. I use this as an example to simplify things. It's like getting 100 pizzas from somewhere. You get 100 pizzas because you've got to feed some folks, but you don't have stoves to cook them, and you don't have cooks to do what needs to be done. And by the way, we actually need more than 100 pizzas too. We don't have what we need to do what we need to do in Riverside and San Bernardino County. AB 1793 has shown us and reminded us of the problem that we've always known is there. By the way, quickly I'll say, and I'll end here, there's some scuttlebutt about San Bernardino seceding from the state in response to its funding problem. And the reason why I'm addressing this is that I posted about this particular press conference, and immediately someone sends me an article of the gentleman, the developer in the area, that says because of the funding problem, we ought to secede from the state. We do not join in that recommended result. We are not better apart, we're better together, but we still need to get it together. The good news is that the state knows that this is a problem that needs to be fixed. They started along the road, whether it's through advocacy, public opinion, or yes, litigation, and some of all of the above. They have to finish the job. Let's get on the road so that the resources of the state can finally match the commitment and dedication of San Bernardino, Riverside County courts, judges, clerks, staff, and others, so that people can get the service that they need and deserve all over the state. As I always say, in that regard, we are here to help. With that in mind, are there any questions?
When will the lawsuit be filed?
The lawsuit was filed 2 to 3 weeks ago. If you need a copy, I'll give it to you. It has the case number, but it has been filed already.
And what happens next when Mike has come in front of the courts?
The first hearing is probably in the next 2 to 3 months. There would be a matter of, as a class action, going through certain steps, certifying the class action. We actually seek injunctive relief. We don't seek financial relief for the individuals themselves. We actually seek not only a carrying out and a finishing of what AB 1793 is supposed to do in these counties, but actually a change in the funding formula that allows us to fund these counties the way that they need to be funded. Okay, well, thank you very much.
Good luck.
Thank you. Nice job.